Member Carlisle,
Yes.
I am in the room, but I'm having great difficulty. I can't turn my camera on, having tried to solve a problem earlier today. So I may have to be here in the room, but not with my camera on.
Okay, that's Member O'Neill for everyone listening in.
Less than ideal. I'll continue to try to fix it, but
No, that's all right, as long as we get it sorted out for the main hearing. Whoever's in charge of the screen, the slide on the screen, can you take that down, please? Lovely. Just make sure that the rest of our members are here. I can see Member Briscoe on the screen. The Burgermeister, can you turn your camera on, Kim?
It is on. I may be on the next page.
So you might be on the next page. Okay, good stuff. All right, we'll make a start. Good morning, everyone, and welcome to the directions hearing for the Viva Liquid Natural Gas Import Terminal Supplementary EES, or Environment Effects Statement. I'd like to start the directions hearing today by acknowledging the traditional custodians of the land on which we're meeting. For me, that's the Wurundjeri people. Others may be located on the lands of other traditional custodians, and the land that we're going to be discussing through this process is Wadawurrung land. I acknowledge the deep and continuing connection of the traditional custodians to their country and their care for the land, seas and sky of their country over many thousands of years. And I pay my respects to Wurundjeri and Wadawurrung elders past and present, and to all First Nations people who may be joining us here today. Just a reminder that we are recording today's directions hearing. It's an audio recording only, and a link to the recording will be put up on the Engage Victoria website later in the week if you need to listen back to anything that's happened today. Now, we'll go through introductions in a moment, but I'm just going to go through a couple of protocols for online hearings for those who may not have done online hearings before. If everyone can just keep your microphones muted and your camera off, unless you're intending to speak today. If you need to raise something with the committee, just use the raise your hand button, which is in the top toolbar on your Teams screen. And then I'll call your name when it's your turn to speak, and you'll just need to remember to unmute yourself and turn your camera on when you're called. People, we just ask that you don't use the chat function. There's a lot going on in a directions hearing, and if you pop a question in the chat, I'm likely to miss it. So just use that raise your hand button instead. If you have a pen and paper handy, I'm just going to give you a phone number for technical support. So the proponent has organised technical support for today's hearing, and we'll have technical support for the main hearing as well. Our technician is a guy called Ken from a company called Total Events, and his number, if you need to speak to him, is 0408 694 643. Okay, so we're going to move on to introductions. My name's Sarah Carlisle, and I'm the chair of this inquiry and advisory committee. I've been a senior panel member with Planning Panels Victoria for around 7 years, and a sessional member for 3 years before that. My background and experience is in planning and environmental law and major project assessments and approvals. I'm going to get the other members of the Inquiry and Advisory Committee to introduce themselves and explain a little bit about their backgrounds and expertise. And I'll start with the Deputy Chair, Member O'Neill, even though he's having camera difficulties today and you won't be able to see him, but you will be able to hear him. Over to you, Bill.
Thanks, Member Carlisle. My name is Bill O'Neill. I'm on Dja Dja Wurrung country, based in Castlemaine currently. I'm a senior sessional member with Planning Panels Victoria and worked with panels for approximately 25 years. I am a strategic and statutory town planner and also have a background in regional economics. I was a member of the committee on the first EES hearing.
Okay,
Thank you.
thanks, Member O'Neill. Member Briscoe.
Thank you. My name's Sandra Briscoe. I'm a sessional member of PPV, which I've been since 2018, and I've sat on a number of EES matters. My background is in environmental science and management, and for this EES, I'll be focusing on the marine environment, including the hydrodynamics and the ecological aspects of the matter.
Thanks, Member Briscoe. And Member Burgermeister.
Thank you, Member Carlisle. My name's Kim Burgermeister. I'm a mechanical engineer, but I specialise in acoustic engineering. I've done that for about 25 years as a consultant in the industry and specialise in assessments, noise assessments for industrial facilities. This is my first panel. Maybe I shouldn't admit that, but that's what it is. And I'll be working on air quality and the noise assessments.
Okay, and if you're wondering how to address us, you can address us as Member Carlisle, Member O'Neill, etc. We're being assisted throughout this process by Amy Selvaraj, who's also in today's directions hearing. So you will have received correspondence from Amy, and if you have any questions or queries about the directions hearing or about the directions that we'll issue after today's hearing, you can contact Amy on the planning.panels@transport.vic.gov.au email address. Okay, now declarations. So we have been appointed to this inquiry and advisory committee because of our experience and our independence. Member Briscoe has some declarations to make, so I'm just going to hand over to you.
Yes, I have two declarations. The first is that I'm a committee member of the Bellarine Bayside Foreshore Committee of Management. And the second is that in my work as an independent environmental consultant, I've done minor consultancy work for AECOM's Adelaide office.
But that wasn't related to this project, was it? No.
It was related to work in South Australia.
Okay. So the remaining members have declared that we have no conflict of interest in this matter, although, as Member O'Neill mentioned, it's worth noting that both, myself, Member O'Neill and Member Briscoe were all members of the Inquiry and Advisory Committee that considered the original EES back in 2022. Does anyone have any questions or concerns that they'd like to raise in relation to those declarations? No? Okay. Now we'll move on to introductions from the parties. So as you will have seen from the letter that we circulated last week, we've had around 69 parties who've requested to be heard at the hearing. We won't have time for introductions from all 69 today, but I will ask that the proponent, the Impact Assessment Unit, any government agencies who might be here or represented today, incorporated peak bodies and community groups to introduce yourselves, and also anyone who's represented by a lawyer, if you could introduce yourselves and let us know who you'll be representing. So anyone who is going to be introducing themselves, if you can just put your hand up using that raise your hand button, and I'll come around in turn. And if you have a preferred way of being addressed, just let us know when you introduce yourself. So I'm going to start with Mr. Townsend.
Good morning, Member Carlisle. Announcing the appearance for Viva Energy, which is the proponent. There are 4 barristers I'll name. Myself, Chris Townsend. Secondly, Barnaby Chessel, SC. Roshan Chahal and Stephanie Mann. From time to time, the case will be in the hands of myself or Mr. Chessel as lead counsel. We are instructed by Kayla Gregg, partner of Davis Advisory.
We have Sean McArdle on the list as well. Is Mr. McArdle going to be appearing in this matter?
No, he won't be appearing.
Okay. Thank you. I'm just going to go around on the screen here. Ms. Chorn?
Good morning, Member Carlisle. Ms. Chorn, I appear on behalf of the Environment Protection Authority, EPA, and I'm instructed by Ms. Chloe Hall within EPA Legal.
Okay. Thank you. Welcome. Ms. Collingwood?
Good morning, Member Carlisle. I'm appearing on behalf of Geelong Grammar School. Today I have Serena Armstrong appearing with me, and at the hearing we'll have Mr. Finanzio SC leading us. We're instructed by Harwood Andrews.
Thank you. Ms. Clooney?
Thank you, Member Carlisle. Jane Clooning, and I'm on behalf of DECA Regions.
Thanks, Ms. Clooney. Mr. Gutierrez Gonzalez?
Thank you, Member Carlisle. My name is Marco Gutierrez, and I work at the Department of Transport and Planning Impact Assessment Unit, and I'm joining the call with my colleague, Brianna Mitchell. And as part of the unit, we've been administering the supplementary EES process for this project on behalf of the Minister for Planning. Thank you.
Okay, thank you. Welcome to you both. I've only got a first name there, Freya.
Hello, Member Carlisle. My name's Freya Leonard. I'm the No More Gas Campaign Coordinator for Friends of the Earth Melbourne.
Sorry, while I just type. Okay, thank you. Mr. Foister? We can't hear you, just on mute, Mr. Foister, if you can unmute yourself.
Thank you, Member Carlisle. Can you hear me okay?
Yep, perfect.
Sorry, I'm just on my mobile. I'm having broadband problems. My name's Greg Foister, and I'm the Rivers and Nature Campaign Manager at Environment Victoria.
Thanks, Mr. Foister. Neil?
Yes, I'm Neil Blake. I'm with the Port Phillip Eco Centre, and my role there is Port Phillip Baykeeper.
Okay. Thanks, Mr. Blake. Ms. Donkers?
I'm Karina Donkers from representing Geelong Sustainability.
Thanks, Ms. Donkers. Now, Ms. Chorn, you've got your hand up still. Is that from the previous introduction or?
Yes, sorry, Member Carlisle, that must be an error. I'll see if I can unraise my hand.
Okay. Are there any other introductions? I'll just flick over to my other screens to see if there are any other hands up. No. Okay. All right. Now, first, I'm just going to outline our role. So we've been appointed as both an inquiry under the Environment Effects Act to assess the supplementary environment effects statement prepared by the proponent for the project. And we've also been appointed as an advisory committee under the Planning and Environment Act to assess the updates to the draft planning scheme amendment that would facilitate the project. So we're a joint inquiry and advisory committee, so I will refer to us as either the committee or the IAC. Now, our role and purpose are set out in terms of reference that were issued by the Minister for Planning on the 8th of September 2024. Our terms of reference are available on the Engage Victoria website. And our terms of reference make it clear that our role is to assess the relevant environmental effects of the project only. The relevant environmental effects are those dealt with in the supplementary EES. So they are impacts on the marine environment, noise impacts, impacts on air quality, and impacts on underwater cultural heritage. Clause 6 of our terms of reference make it clear that it's not the role of the Inquiry and Advisory Committee to re-examine project effects beyond those 4 relevant environmental matters. So we won't be revisiting other matters that were dealt with in the original EES inquiry process. Now, our task in relation to the supplementary EES is to review and consider the supplementary EES relevant referenced material and submissions in relation to the relevant environmental effects, to consider and report on the significance and acceptability of relevant environmental effects, having regard to relevant policy and legislation, to consider and report on the updated assessment of likely significant impacts on relevant matters of national environmental significance, so those that are assessed under Commonwealth legislation, to consider new information in the supplementary EES that's relevant to the EPA development licence applications, to identify any additional mitigation measures or modifications to the project beyond those identified in the supplementary EES to avoid, mitigate or manage the relevant environmental effects, and to advise on how those measures and modifications should be implemented through the necessary approvals and consents for the project. Our task in relation to the updated planning scheme amendment is to review the updated planning scheme amendment, to consider any issues raised in submissions that relate to the updates to the planning scheme amendment, and to recommend any changes to the updated planning scheme amendment that we consider necessary to address the relevant environmental effects. The terms of reference state that we must conduct a public hearing and to provide a report to the Minister for Planning within 6 weeks after the conclusion of the hearings. The terms of reference set out a number of matters that we must include in our report in clauses 42 and 43, and we encourage the parties to have a read and be familiar with the scope of the matters that we must consider and the matters that we must report on when preparing their presentations to the committee. And equally importantly, parties should note what's outside our scope. So in particular, it's not our role to re-examine project effects that are outside the scope of the relevant environmental matters. Now, the purpose of today's directions hearing is for everybody to introduce themselves, to consider any preliminary or procedural matters, to make arrangements for the hearing and for site inspections, to consider timetabling issues, to give some directions about the conduct of the hearing and the exchange of information in the lead up to the hearing, and to answer any questions people may have about the hearing. It's not the purpose of the directions hearing for people to give submissions or offer their opinions about the project. That opportunity will come at the main hearing. So today I'll be providing just a little bit of background to the process, including a high-level description of the project. We'll then outline the information that we have received so far and the broad themes that have been raised in the submissions insofar as they relate to the relevant environmental matters. After that, we'll give you some information about how hearings are run. We'll make some arrangements for the hearing and for the site inspection. We'll deal with some procedural matters. We'll have a discussion around providing information to the committee in the lead up to the hearing, including the exchange of evidence. And we're going to outline the directions we propose to make. Now, depending on how we go, we may need to take a break, but I'm hoping we'll be able to run through and finish the directions hearing without needing a break, but we'll see how we go. Okay, so just a very high-level overview of the project. So the project is a proposed liquid natural gas import terminal at Geelong to be located at Refinery Pier alongside the Geelong Refinery. The proponent for the project is Viva Energy Australia Pty Ltd, so I'm just going to refer to them as Viva. Viva also operates the refinery. The key objective of the project is to facilitate a supply of gas for southeastern Australian gas market to address a predicted shortfall in supply in southeastern Australia in coming years. The project will consist of a floating gas terminal. It's a ship known as a floating storage and regasification unit, or FSRU. The FSRU would be permanently moored at Refinery Pier, and it would receive liquefied LNG from visiting LNG carriers who would offload the LNG into the FSRU, where it would be stored and then regasified to meet the demands for residential, industrial and commercial gas use. The FSRU would be up to 300 metres long, with the capacity to store around 170,000 cubic metres of LNG. The FSRU would store the LNG in liquid form on board in cryogenic storage tanks that are kept at around minus 160 degrees centigrade. And when gas is required, the FSRU would use seawater from Corio Bay to warm the LNG and convert it into a gas. It'll then be transferred through a 3-kilometre above ground pipeline from the refinery pier into a new treatment facility to be built on the refinery site. It'd be treated there to meet Victorian transmission system specifications and standards. It will then be pumped through an underground pipeline to a connection point around 4 kilometres away at Lara. So the project will necessitate the extension of refinery pier. That'll need to be extended to accommodate the FSRU and the visiting LNG tankers. That will include a 570-metre long angled pier arm, a new berth and ancillary pier infrastructure, including some high-pressure gas marine loading arms and transfer lines. One of the key elements of the project is the proposed reuse of the seawater that's used in the regasification process on the FSRU as cooling water in the refinery. So our understanding is that the refinery currently sources its cooling water directly from Corio Bay. Now, just a little bit about the previous EES and how we got to where we are now. So in December 2020, the Minister for Planning issued a decision determining that an EES was required for the project under the Environment Effects Act due to the potential for a range of significant environmental effects. So the original EES, including 16 technical reports addressing the potential environmental effects of the project, was prepared. It was publicly exhibited from February to April in 2022. The Minister for Planning appointed an inquiry and advisory committee to advise on the project, the EES, the draft planning scheme amendment, the development licence applications. So there's 2 of those, one for discharges to air and one for discharges to Corio Bay, and the pipeline licence application. So the original committee conducted a public hearing from June to August in 2022 and submitted its report to the Minister in October 2022. And on the 6th of March 2023, the Minister for Planning directed that a supplementary statement be prepared for the project before the Minister could complete the assessment of the project's environmental effects. And that's how we've got to where we are today. So in terms of the submissions and information received to date, we have been provided with a copy of the exhibited supplementary EES materials. Now that includes 5 technical reports. We've got technical report A, which is the supplementary marine environmental impact assessment. Technical report B, which is the supplementary threatened and migratory birds impact assessment. Technical report C, which is a supplementary air quality assessment. Technical report D, the supplementary noise impact assessment. And technical report E, the underwater Aboriginal cultural archaeological assessment. Now, I just wanted to note that that technical report wasn't exhibited publicly as part of the EES materials at the request of the Wadawurrung Traditional Owners Aboriginal Corporation, because it contains some sensitive cultural heritage information, but the Inquiry and Advisory Committee has been provided with a complete copy of that on a confidential basis. We've also got an updated assessment of the impacts on matters of national environmental significance that need to be assessed under the Environment Protection and Biodiversity Conservation Act. And we have updates to the planning scheme amendment. We have a copy of a peer review of the hydrodynamic modelling and marine ecology assessment for the supplementary EES. That's the Stantec peer review report. And we have a copy of the 387 submissions that were received in response to the exhibition of the supplementary EES. Now, just in terms of submissions, so the EES was exhibited from the 12th of September to the 24th of October on the Engage Victoria website, and we've received 387 submissions, most of which oppose the project or seek changes to the project. That includes 2 late submissions that we've accepted. So there was a submission from the Australian Manufacturing Workers Union that we received on the 30th of October 2024, and that's submission number 387. And then we've received a late submission from Environment Victoria on 31st of October 2024. I think we might have had a holding submission from Environment Victoria because the submission number is submission 332. So that's just we received something during the exhibition period, and then we've received some more detail since. Okay, so we also received a late submission from Ms. Kriya, and she was requested to complete a cover sheet so that we could process that submission and consider it as part of the materials before the IAC, but we never received a completed submission cover sheet, so that submission hasn't been processed. Now, in accordance with our terms of reference, all submissions are available on the Engage Victoria website. In some cases, some personal information has been redacted from the submissions before we put them up online, just to make sure that Planning Panels Victoria is meeting its privacy obligations. We've also been provided copies of submissions to several agencies as required under our terms of reference. They include Viva as the proponent, the Impact Assessment Unit at the Department of Transport and Planning, the Wadawurrung Traditional Owners Aboriginal Corporation, and the City of Greater Geelong. We're maintaining a document list through the hearing, and that will be updated regularly on the Engage Victoria website. The document list is pretty small at the moment. There's only 4 documents on it, but that includes the correspondence that you will have received from the committee, and the correspondence that we received from Geelong Grammar School and from the EPA last week, indicating that there are procedural matters that they wanted to raise at today's directions hearing. So I'll come back to those. Next up is to just outline the issues that have been raised in submissions. So submissions have raised a number of issues in relation to the relevant environmental effects. We circulated those in a letter to the parties or to all submitters dated the 6th of November, and they are the further technical work required by the original Inquiry and Advisory Committee has not been undertaken or was inadequate. Concern that the technical basis underpinning the supplementary EES has not been made public. The peer review of the technical reports was inadequate, and the supplementary EES did not adequately address the concerns that were raised in the peer review. There's no way to verify the source and accuracy of external information relied on in the technical reports. Existing marine conditions have not been accurately determined, including because the marine surveys were not carried out over a full annual cycle. Concerns with the hydrodynamic modelling, including calibration of the model. The assessment of seagrass is inadequate, including concerns regarding the seagrass mapping and the extent or the assessment, of existing impacts. Concerns that dredging will be more extensive than indicated in the supplementary EES. Concerns over whether the proposed monitoring and management of dredging impacts is consistent with the Victorian dredging guidelines. Concerns about whether the baseline conditions relating to air and noise emissions from the existing refinery have been accurately determined. and concerns about whether volatile organic compounds have been included in the air modelling and whether the assessment has adequately considered VOCs and their potential secondary air pollutants. Concerns that noise emissions from the proponent's current operations haven't been brought into compliance and the proposed noise mitigation outlined in the supplementary EES may not be effective in enabling the project to operate within appropriate noise limits. And assessment in relation to cultural heritage significance is incomplete. And in particular, there were concerns over the proponent not having released technical report E and the cultural values assessment. Now, the Environment Protection Authority in submission 330 has raised a series of issues in relation to the supplementary EES, the development licence applications and the environmental management framework. And the EPA has made 19 recommendations spanning requests for further work and edits concerning marine air quality and noise. DECA Regions in submission number 338 has raised some issues in relation to native vegetation, including seagrass and the environmental management framework. We did receive some supporting submissions for the project, and those submissions raised the following key issues. The project would be seen to provide a credible solution to Victoria not running out of gas. Geelong would benefit from the economic impacts of the project, and the project will protect existing jobs and industry by addressing projected gas supply shortages. Now, those are very high-level summaries of the issues, and many of those issues are quite nuanced and detailed, and we'll be exploring those issues in more detail at the hearing. Submissions also raised a number of issues that don't relate to the relevant environmental matters. So key concerns there were that the project's impacts on climate change, consistency of the project with net zero policy and legislation, and safety and hazard concerns around locating the project close to residential areas and schools. Now, those issues were addressed through the original EES process back in 2022, and in accordance with our terms of reference, we won't be considering issues raised in submissions that don't relate to the 4 relevant environmental matters, and we won't be able to spend time at the hearing on concerns from submitters that are not within the remit of the committee to consider. Now, further to the matters raised in submissions about the relevant environmental matters that I've just summarised, based on our technical review of the documentation we've received to date, we wanted to flag the following matters that we'll be seeking to explore at the hearing. The first is impacts on the marine environment, including the updated regional hydrodynamic model, thermal and chlorine plumes, including variability in the extent and direction of the plumes, the effects of chlorine and chlorine byproducts on marine biota, sediment plumes from dredging, including variability in plume extent and direction, and impacts on seagrass. We're going to be seeking to explore a resolution of the outstanding matters from Stantec's peer review of technical report A, including consulting environmental engineers' response to that peer review. We note that Stantec was happy with technical report B, which was the impact assessment on threatened and migratory birds. We're going to be looking at baseline air and noise monitoring, and in particular whether the number and location of the selected additional monitoring locations that have been adopted for that baseline monitoring are reasonably representative of the range of existing conditions experienced at residential and commercial receivers that could be impacted by the proposal, and whether air monitoring results from South Geelong are applicable to the air quality at other residential locations near the project. We're going to be looking into whether volatile organic compounds and potential secondary air pollutants have been adequately considered in the modelling. And we are also going to be looking at compliance of current operations with the noise limits in the noise protocol and what that will mean for compliance limits for the project. So that's based on our review of the materials to date, and other issues may arise and need to be explored through the course of the hearing. Just a point of clarification that we wanted to seek. So we understand that, this is one for you, Mr. Townsend. We understand the hydrodynamics report from 2024. I think the title of that document is Refinement of Regional Hydrodynamic Model of Corio Bay for Supplementary Marine Studies, wasn't included in the exhibited materials. Is that correct?
I don't know. Perhaps if you can give me the full questions and I can just get some instructions and come back to you in a moment.
We think it's not included. So this is the hydrodynamics
let's
report.
Operate on the basis it isn't for the supplementary question, and I'll
So what we really want is to, we think that should be circulated as soon as possible, so that relevant matters can be understood, not just by us, but also by the other parties. So we just wanted to find out how quickly that could be circulated.
Understood. All right. Can I come back to you on that during the morning?
Yes. Yeah.
Thanks.
Okay, so next on the agenda this is some information for those of you who may not have participated in an inquiry and advisory committee hearing process before. So just as a reminder, we did attach a guide to hearings at PPV to our letter that went out on the 29th of October, just advising you that we'd been appointed to consider the matter. The guide sets out in quite some detail what happens at a hearing. It explains the differences between an advocate, an expert, and a submitter, and what those the roles of those various participants are in a hearing. It explains who can ask questions and who can be asked questions in a hearing. Generally speaking, only experts can be asked questions by other parties. It also gives you some information on how to prepare a submission and how to present a submission to the IAC. So I urge those of you who are not familiar with our processes to read that guide before you prepare your submissions and before you prepare any questions you might have for the experts. It's got some really useful information in it. Some key points to note about the hearing is that it will be public, and we are going to be recording the hearing. That will be an audio recording only. Any material provided to the committee will be a public document unless you're granted approval from the committee to present material confidentially. If you do want to present material confidentially, you'll need to seek the approval of the committee to do so and provide reasons as to why the information needs to be confidential, because the starting premise for all IAC processes is that the process is a public process. We'll be conducting the hearing in person, but with some video conferencing facilities, so people who aren't able to make it to the hearing in person can still participate and present online. I'm going to come back to hearing format shortly. We're expecting to present we're expecting parties to present material at the hearing electronically, and there's some detailed instructions in that guide that I mentioned before on how to screen share, whether you're in person or whether you're logging in and presenting online. We'll also have technical support available through Total Events for both our in-person and online participants during the hearing. And if you are presenting in person at the hearing, there will be someone from PPV to help you sort out screen sharing and those sorts of things if you need any additional assistance. Now, generally, we ask parties to circulate the material that they want to present to the Inquiry and Advisory Committee the day before, but don't assume that the committee or the parties will have pre-read that material. That's really just so we can get the material organised on our screen so we're ready to go when you present that material. Now, just a reminder that any material that you want us to consider has to be provided at the hearing. It's only in very unusual circumstances that we would accept material outside the hearing process. And that's because we need to make sure that the process is transparent and that all the parties are aware of the material that's been presented to the IAC and has been considered by the IAC, and that everyone has the opportunity to respond to that material. Okay, I'm just going to outline the requests to be heard. So we provided some information about that in our letter from last week, but we've got 69 requests to be heard, and we've got 3 parties who are intending to call evidence, and we just need some clarification on that. So firstly, from Viva, so the proponent has requested a week. We're just wondering, Mr. Townsend, whether you mean 4 sitting days or 5 sitting days, because normally we don't sit on Fridays if we've got a hearing that goes longer than a week, but because of the December timing, we may have to sit 5 days at least in the first week. So are you talking 4 days or 5 days?
I wonder if you gave me about 3 minutes, if I could answer it the long way, because I've had chats with my friend Mr. Finanzio for the school as well, and I can probably cut to the chase on a bit of this by talking about the timetable, but answering your question about timing at the same time. Is that okay? And it might raise a couple of matters, but just a convenient way to do it. So if I go first, and then that trips you up on anything you had in mind, then we can flush that out and hear from others. But it might mean that I can make things a little more efficient if I address you first. The first thing to say is that they're really, logistically, there's the timetable and there's the location, and I'll come back to that in a moment. And then there's this number of witnesses and time, the question you've just asked. The point about the third question is that we understand the preference of the school, and I'm told the way the committee handled it on the previous occasion to do evidence in blocks under themes. From Viva's point of view, we just want to cooperate with the committee. So if that suited you, that's no difficulty for us, but it will affect the question you've just asked me. So I have prepared to address you on the basis of meeting that suggestion of the school that we do the evidence in blocks. And if you're happy for me to address you on that basis, it comes back to the 4 and the 5 day question. So staying on that issue for a moment, our suggestion from a timetable point of view would have been that using the 4 day week model, that in week 1, the 9th, day 1 might be whatever refresher or explanation you require, and hearing from agencies, if possible, including the EPA, at least from an opening point of view. And that then then we'd move to the evidence blocks, and the first would be marine environment. And we'd been having, when you've heard from everyone today, you might determine whether you think it's appropriate to set 2 days aside, Tuesday, Wednesday, to hear from those who are calling experts in that matter and allowing some opening remarks, whatever it may be, or whether you think it's appropriate to have the Tuesday, Wednesday and the Thursday if you think it's going to take longer. And that would be topic 1, assuming you don't use the Friday. We would then suggest on the Monday that you would be having air and migratory birds. And I'm deliberately leaving Aboriginal cultural heritage aside for a moment because I'll address you on that separately in a moment. And that would, if that were the case, you would in the second week, the Tuesday, Wednesday and Thursday as a reserve day, you would have the noise experts. So if you followed that model,
hang on,
we think that, I'm sorry.
I'm having trouble keeping up. So week 2, the Monday would be air and birds.
Yes. And then the Tuesday, Wednesday, and perhaps reserve Thursday, noise, all parties. On the Monday, we might have some mopping up to do for our case, but we try and get that done as part of the previous days. Then that would leave you with a block of time. We're guessing, say, 4 days, where you'll be in January, where you've got we think there's a couple of days of submitters apart from the school, and then the school will still need a day having called their evidence, and you might have a day for replies. So if you followed that model, can I say just a couple of other things from our point of view? One is we're trying to consolidate as much as we can the evidence into a witness where we can. So we're trying to keep the number as slim as we can.
Yep.
For marine, we would definitely be calling Ian Wallace, and depending on our review of all the materials, whether we need more or not, we will let you know by Friday.
Yep.
On the matter of acoustics is the same. We will be calling Tom Evans, but we're going through material and submissions, and again, we'd let you know by Friday, but we're hoping to consolidate the evidence into the one witness.
Yep.
Likewise with air, it's Mr. Rawlings. That is a single witness, and we have Mr. Lane as the independent reviewer on migratory birds. So they're definitely single witnesses. While I'm just addressing you on evidence, and this is a matter for the committee separately, but we thought you may wish to at least allocate a slot in your timetable of, say, an hour for an in-camera session on underwater Aboriginal cultural heritage.
Yep.
We were minded to separately supply you with a submission and or comment from the author of a status update, if you like, from the author. I am at liberty to say to you today that in our consultation with the Wadawurrung Traditional Owners Aboriginal Corporation, that we understand and are aware they do not intend to appear at the hearing, and that the topic generally, as far as they're concerned, including underwater Aboriginal cultural heritage, is now moving to discussion and preparation and consultation of CHMP. So it will be a matter for you at some point to let us know whether you need to hear anything more than we would file. But I'd be suggesting from a timetable point of view, you might perhaps on a fifth day, even on a Friday of the first week, you might just allow an online slot in case you require us to address you on that issue, and you might decide between now and then whether that's necessary or not. So if we took that view, it seemed to me you would get your evidence block done and heard from the agencies at least by way of opening prior to Christmas, and you'd be looking at a 4-day slot in January. I wonder if I'm talking, can I move it to a venue discussion now, just because it might be relevant to how many days you set aside. Yep. We understand the school will address you and ask for the whole hearing to be in Geelong, and our primary position is Viva's here to cooperate with whatever suits the committee. However, we think there are logistical preferences that pretty strongly lean to what you've suggested, which is to do the pre-Christmas block in Melbourne and then have a week in Geelong in January for the local submitters, particularly if all the evidence is being heard in a block, and given the amount of witnesses that'll be around Melbourne, or in our case, coming from interstate. But I need to say this, no matter what the committee decides today, there is an immediate logistical issue, which is a venue, if the hearing is to be in Geelong. At this stage, from our inquiries, we don't have one, but we would obviously find one if the committee wanted to hear the matter in Geelong. But there is a very strong parallel proposition that I would suggest is an important one. If you're having a hearing in Geelong in those weeks, we need a room that is exclusive because we're setting up IT. There's nothing worse than having a hearing where you have to set up the room every day. And in those 2 weeks prior to Christmas, with the amount of functions in venues, that is easier said than done. So that, no matter what proposition you arrive at today, an immediate qualifier will have to be, can we get an exclusive room that's big enough and for the IT in that period? Of course, our preference is, I'm assuming that this committee sitting at that time of year would have good access at PPV to hearing room 1, I'm assuming. And if that were the case, it might not be a safe assumption. That might affect you also. So that's another matter. If you're going somewhere else anyway, my guess is the same issue will be in Melbourne and or Geelong, but we need to make sure we've got a room with exclusive access for those weeks. But Viva will otherwise do its level best, whatever suits you. But obviously we'd say there's a strong logistical leaning towards Melbourne for the evidence block, and then a week for Geelong. If you're with us on all of that, the other matter for your timetabling would be, if you wanted to have a site inspection, if you're doing a tranche in Geelong, you could fit that in. Otherwise, we can make arrangements prior to the hearing in the week of the 2nd December. And I just wanted to let you know that as far as timing goes for that, we're assuming a more targeted site inspection than the committee had on the first occasion, and therefore it'd be in the order of a half day, you know, or day at worst, not a, I understand you had a 2-day one last time, but I'm told we could consolidate that because you'd look at really the shoreline areas for noise and marine, and a bus tour around the facility for the newer members, perhaps. So they were, if that was an indirect way of answering your question about the numbers of witnesses, but hopefully I've answered it along the way, that it would mean that subject to what we tell you on Friday, we're trying to keep it 1 witness per topic, and that would mean, and we're assuming one way or another, it may not mean the underwater Aboriginal cultural heritage, so 4 experts as I speak today, with any supplementary ones advised on Friday.
Okay. And would you be thinking of calling Mr. Wallace and Mr. Lane sort of together to have that discussion around marine impacts, or do you think they're separate?
There is obviously an overlap on what the birds eat, and so we could, but they're separate chapters. It seemed to us neat. If you're going to do it in blocks, you sort of deal with that chapter, then we go to the next chapter. But we would do it. What we do is make Mr. Lane the first witness. We follow marine with birds, and we could always keep Mr. Wallace in the vicinity or available in case the committee wanted to have any crossover questions.
Okay. I might just go to you, Ms. Collingwood, because that kind of really related to a bunch of issues that the school had raised in terms of logistics. Can I ask whether you've made decisions around witnesses and whether you've retained any witnesses yet?
We have retained a couple of witnesses. At the moment, we're looking at calling evidence in respect of noise. And we're also looking at calling evidence in respect of marine ecology.
Do you know who you've got yet, or?
We'll be calling Matt Edmonds in relation to marine ecology, and we'll be calling Darren Tardio in relation to noise. We think that if we were to call all of our evidence and make submissions together, our case would take about 3 days. Can I address you globally on the matters that Mr. Townsend has raised, starting off, first of all, with the notion of hearing expert disciplines thematically. We think that is, look, we're happy to be guided by the committee and what's most convenient to the committee, but we think it's sensible to hear expert disciplines thematically, particularly where they are based on technical and complex matters. It enables the witnesses to stick around for the opposing evidence. It also enables the committee and parties to be able to explore issues on the spot whilst matters are fresh in their mind. And it also avoids the necessity for witnesses to appear on more than one day if they want to observe their opposing counterpart. So we think that is sensible, but either way, the matters that we've raised in the letter that we sent on the 7th of November are really important to the school. One of the most important issues relates to the timetabling and sequencing of the hearing. We're really concerned about having the conclaves right before the hearing and circumstances where the conclave reports might not be ready before the hearing starts. I understand that happened at the last hearing where there were some conclave reports that were filed after the commencement of the hearing. What needs to happen is that once the conclave reports are finalised, we need the opportunity to seek instructions from our witnesses about the subject matter that's been agreed, hasn't been agreed, and that can involve some lengthy and technical discussions. And I understand that on the last occasion, Mr. Finanzio had to miss a couple of days of the hearing in order to undertake that analysis. So what we had suggested in our letter is the reverse opposite of Mr. Townsend's suggested order of witnesses. We'd like two things to safeguard against that happening again. The first is for the conclaves to be held in the week of the 2nd of December, with a direction from the committee that the conclave reports be filed on Thursday, the 5th of December. At least that gives us the Friday before the hearing commences and the weekend to work on that material. You can understand the difficulty in then having to stump up on the Monday and cross-examine on material if the conclave report hasn't been provided. So the second way to avoid that circumstance is if those matters that are not substantively in dispute or where there's no opposing evidence are called first, then that can create a buffer to postpone the really contentious issues towards the back end of the hearing, or rather the middle of the hearing, to enable those instructions to be obtained. So, for example, we would be suggesting that the issues of air quality and migratory birds be heard up front. We're not calling evidence in air quality. And what that means is that we'll have that time to explore elsewhere with our marine ecology witness those really complex issues that are going to be raised on the evidence.
Yeah.
But the other aspect of this that's really important is that, and which will assist in alleviating our concerns, is if material that's relevant to the preparation of our witness expert reports is provided early. And I'll come back to that later after we've addressed these timetabling issues. But we really need to make sure that our witnesses are able to undertake work at the front end of the preparation, and that they're not required to assess new material that might be complex right as we approach the commencement of the hearing. We don't think that that's a fair approach. So we also want to be cooperative, but we're looking for a way to be able to manage the hearings so that it's fair and it gives all of the parties an opportunity to fairly present their case. In terms of hearing dates and locations, we do think it's sensible for you to set on 4 days rather than 5. These matters are really complex, and it is beneficial to have that reserve day each week, particularly given the technical work and the technical evidence that's been given. These matters invariably result in a lot of material being filed on the run, and so it's important to have that reserve day, and we support the committee's proposal to proceed in that way. In terms of the location of the hearing, the community members might have something to say about that this morning as well, but we are strongly of the view that the matter should be held in Geelong in its entirety. There remains considerable community concern in relation to this proposal and community involvement in the hearing. The hearing was listed in 2022 in Geelong and was only moved online because of COVID. Nothing's changed that would warrant a different approach here. We think it's sensible to hold the hearing within the community which is concerned with the subject matter of the hearing, and almost all of the submitters are Geelong based. But there's also another aspect to this, and that is that we understand that Geelong residents might be given the opportunity to present their submissions in Geelong, but they really ought be given the easiest opportunity to attend the hearing when evidence is being called, to listen to that hearing evidence and participate if they wish to do so. And we're of the view that the balance of convenience strongly favours the location that is most easily accessible for the community. We hear what Mr. Townsend says about venues. Can I say Mr. Tobin's a local of Geelong, and he was able to rattle off to me this morning half a dozen venues that might be available. I'm not aware of the footwork that's been done by Mr. Townsend's team to locate a venue, but there's a football club. The council's presently being used for a panel. There are numerous hotels with conference facilities. So we just think that before we shut down that opportunity, we need to make sure that that footwork has been done, and we're happy to make some calls if that would assist the committee. So that's our position in relation to the conduct of the hearing, which I understand is diametrically opposed to Mr. Townsend's proposal. But in terms of the way that the hearing is run, we really need to be cognizant of the quantum and the complex nature of the material, and we need to make sure that there is that buffer there so that we're not put under undue pressure and there's no risk that aspects of the evidence that we might wish to explore are omitted because we just haven't had time to work through the material. And I should say that we are the only or the primary contradictor in this case, and I understand that the case that was run by the school in 2022 was helpful to the committee, and the evidence called in that case on behalf of the school was informative for the committee. And so we think that it's also in the committee's best interest to make sure that we're given an opportunity to present our case fully.
Okay. I'm going to just go to Member O'Neill, who's got his hand up.
Thanks, Member Carlisle. Just a point of clarification that I'm seeking from Mr. Townsend. In your overview, Mr. Townsend, I didn't pick up a time slot for your primary submission. Can you just clarify when you're proposing to deliver that?
Yes, I beg your pardon. In the expected course, we would file a Part A submission, which would be the high-level background document in advance of the hearing, and we wouldn't expect to dwell on that at the hearing itself. For the hearing, we would provide an opening submission within which we would hope to address reasonably comprehensively the issues, given that it's a supplementary assessment. It's not so much a reply case as an address you case on the supplementary work. So that would have been part of my day one role, I thought, Member O'Neill. And then, but we'd probably separately address you because the marine would be part of that. Because the noise is a separate topic, we'd probably in week 2 do you a submission on noise and really open the case with a submission and then the evidence on noise. So there'd be, to some degree, we'd break up addressing you on the topics over week 1 and 2, but it would be primarily day 1 and then probably the commencement of the noise case where we would go to the submissions.
So just to clarify, you anticipate in the schedule you would be finished your openings and your primary submission pre-Christmas, and then you'd have a close post-Christmas?
Yes, and I'm imagining a day at the end of the hearing in that 4-day slot or whatever it is at Geelong that we'd, in that final day, we'd be doing a reply submission. And you might give some time to others to do the same on that day.
Thanks for that.
No, thank you. While I'm talking, can I indicate I had a text during the a correction to something I'd said about arrangements. There is a venue arranged at Clifton's at Freshwater Place if needed for the 2 weeks prior to Christmas. I hadn't understood that to be the case. Thank you.
Okay. Well, let's just break this down. We'll do timetabling first and we'll do venue second. So it sounds like the only aspect that there's not alignment between the school and Viva on in terms of timetabling is the order of the themes.
Can I just say on that, if in week 1, I mean, the spread of the 2 weeks, I don't think it's any different. If for some reason you wanted to have air and birds in front of marine, that's in week 1, that's a matter for the committee. It's nothing that we press.
Okay. I think that would be sensible for the reasons that Ms. Collingwood has outlined. The committee is certainly open to a theme-based hearing. It would be particularly useful for us if we could get all of the evidence done before Christmas. I think the risk of the evidence being broken over a long period, we want to avoid that. So we're happy to go with a theme-based timetable. We're happy to schedule the uncontested evidence first and schedule basically as outlined by you, Mr. Townsend. We'll try and get the marine evidence done in week 1 and the noise evidence done in week 2. In terms of venues, I do need to tell you that neither of the PPV hearing rooms, like we've just got this crazy December and it's very unusual, and we're running hearings right up until Christmas and both the hearing rooms are unavailable. So it's either somewhere in Geelong or Clifton's. They're our 2 options. We certainly don't want to do it online if we can possibly avoid it. Works okay for a procedural hearing like this, but a hearing where we're testing evidence, we really need people in the room. So we certainly as the committee are open to the whole hearing being conducted in Geelong, but we will have to be able to find a suitable venue. So rather than making a decision about that today, I know that Amy's been tic-tacking with the Viva team in the background about the search for a suitable venue, and it hasn't been easy. I think that for now you should keep that booking at Clifton's for the 2 weeks before Christmas, just in case we need it. But we will ask you to renew your efforts to find a venue in Geelong that we could run the whole hearing at.
Can I do so on that basis that we've said also though that it's not somewhere that we'd have to pack up at night or undo, so it is exclusive for that period?
Yes. Yep. I know we're going to have a whole lot of tech kit in there for the recordings and stuff. We don't want to have to be unpacking that every night. Okay, so we're going to leave that with you or with your clients. Mr. Townsend, Amy will be in touch with your team after today. Is there anything that anybody else wanted to say in relation to either the order that we hear the evidence in or where we have the hearing? Ms. Chorn?
Thank you, Member Carlisle. I'm grateful to Mr. Townsend and Ms. Collingwood for outlining their various proposals for how the evidence ought to occur. The EPA is similarly not opposed to a thematic approach to the evidence in this case, and I agree with Ms. Collingwood's submissions about the utility for doing so. The EPA also strongly supports the school's submission about putting the easier, if I can call it that, or the less contentious evidence first. Whilst we're not calling our own independent experts, the EPA, as you'll be able to see from our submissions and our recommendations, does wish to test some aspects of the evidence quite rigorously. So we would benefit from additional time, particularly in respect of the evidence on noise. Further, insofar as the proponent, I understand the proponent indicated that it wished to have an opening from the EPA. We don't object to that, but we would then request an opportunity to be heard by way of reply or closing, whatever language the committee thinks is appropriate following the conclusion of evidence, so that we can tie up any loose ends that have come up following our cross-examination and everybody else's cross-examination. So rather than, I think the committee had previously anticipated a single presentation from EPA, if we want to split that up into a very brief opening and then a sort of tying it up at the end following the conclusion of the evidence, we're happy with that approach.
Okay.
Thank you.
I'm sure that we can work that into our timetable. Any other comments on order of evidence or venues? I'm just going across the different screens.
Member Carl, I thought there was a suggestion there was a third party calling evidence.
Look, there is. Is Mr. Amarina here today? If you are, if you could turn your camera on and say something unmuted so you pop onto our screen. Sure, if he is here today. I haven't seen him in the participant list. Mr. Amarina has asked for 15 minutes and has indicated he's intending to call an expert in energy efficiency, someone called Tim Forsey. We can only hear evidence in relation to the relevant environmental matters, and energy efficiency isn't one of the matters that's within our remit. So I actually don't think we will have 3 parties calling evidence. I think we'll have 2 parties calling evidence, and we'll just need to liaise with Mr. Amarena in the background if he's not here today. Okay, all right. Now that's been a really useful discussion. Thanks for that. You've taken me off the script in terms of the order we're going to do things. So excuse me if I repeat myself. But hearing, look, the next thing I just wanted to check in with, and it sounds like we're all okay with the dates. So we would be looking to sit 4 days in the week of the 2nd of December. But is it the 2nd of December? Sorry, the 9th of December, 4 days the following week, and perhaps with a reserve day in both those weeks, and then 4 days in the week of the 13th of January. Just a final call out if those dates present any problems for anyone. No? Okay. I think we've done hearing schedule and indicative timetable.
Member Carlisle, can I just butt in there?
Yep.
We haven't expressly made our intention about opening submissions. Do we just need to clarify?
Yeah, that's
Heard that EPA are happy, but we were contemplating opening submissions on day 1, also from Geelong Grammar School and Decca Regions, if they're amenable to that.
Yes. Now, Ms. Cluning, we were kind of contemplating a brief opening submission from, like, how we were envisaging day 1 would go is that we get an overview of the project first up from Viva. We would then have the impact assessment unit just providing us with a brief overview of the EES process leading up to the appointment of the committee. That would usually run for 30 minutes or so. And we were then looking for effectively an opening submission from the proponent, an overview of the supplementary work that had been done, brief overviews from EPA and from DECA, and then an opening submission from the school. That was on the assumption that we would then have more substantive submissions from EPA and DECA later in the hearing process. And Ms. John, if I'm hearing you correctly, after the evidence would be a convenient spot to do that. Ms. Cluning, do you have any views on that?
No, not at this stage. We were looking to present an overview, not a detailed submission. You'll see we've not requested that sort of time, but we'd be more than happy, Member Carlisle, to provide information you require or anything we can provide you in that time.
Well, I think you've requested 30 minutes, haven't you, Ms. Cluning?
Yes, it may be a bit shorter than that.
Okay.
We've given a little bit extra time. We could probably cut it back for you if that would make life easier.
In that case, it sounds like we won't need 2 submission slots. If we can just get you to present on that day 1, so we understand where DECA is coming from, and then if you're able to perhaps address any questions that the IAC may have as a result of, the evidence that comes later, we can do that through some sort of written process. Is that amenable?
Yes, absolutely. Or we can probably, if there are those that need to be done, we could probably, like the EPA, provide some time later in the hearing. And we weren't preparing for it, but we're happy to do that to assist the committee.
Okay, terrific. All right. Well, I think we can be a bit flexible on that and just make sure that we've got some time to address anything that might arise if we need it. Did somebody other than the proponent address a closing? Yes, Ms. Collingwood, you sort of had indicated a closing submission from the school as well.
So what we had envisaged would, consistent with Mr. Townsend's comments earlier, we had anticipated that, but we're not wedded to this, that there might be an opportunity for a short opening on each discipline of evidence, and then the evidence to be heard thematically. We're happy to do one opening at the start of the hearing if that suits you better, but what we seek is a closing address on all of the evidence, and that will effectively be our main submission.
Yeah. So we were envisaging that you would do that where timetable.
Can I suggest if you have the school in that third week doing its submission in the Geelong week, at the end of the week, that's effectively a close. It's effectively a closing. So it doesn't you don't need a particular slot. Just put them after the community submitters.
We had envisaged, we thought if we could fit you in before Christmas, we could do that, but we thought maybe we couldn't, and we would have Geelong Grammar's sort of substantive submissions on the first day of that week in January. But if, when we work up the timetable, we can fit you in at the end of the second week after the evidence, would that be something, or what would your preference be there, Ms. Collingwood?
I think what we would want to make sure is that we get sufficient time to present a full closing on the evidence. Where that is in the scheme of things is not something we're overly concerned about. That might necessitate what flows from that might be the need to, or there might no longer be a need to do a reply, but we would certainly want to make sure, well, I think we've indicated 45 minutes for the reply. We would want to make sure that our closing submission is significantly more time than that.
Yes. Now, we were going to allocate you a 3-hour block as requested. Okay, we'll leave that with us. If there's no problems, whether it's at the end of the week 2 or the start of week 3, we'll just see how the timetable falls out when we start putting all this together.
Sorry, if that's the choice, then we would certainly prefer to have the time over the Christmas break to work that up.
Okay.
So if there's a choice, we would prefer for it to be in January, but we're happy to be cooperative.
On our kind of, well, it's not really my adding up of the time, it's Amy's adding up of the time. We think we'll probably need 3 days for the community submitters. So it may be that if we do Geelong Grammar in that third week, we would need to sit 5 days. So we'd have Geelong Grammar on day 1, the community submitters on the Tuesday, Wednesday, Thursday, and then closing submissions on the Friday. Anyone freaked out by that prospect? No. Okay. All right. I think that might work then. Okay. Anyone else wants to say about dates, venues, timetabling issues? You're on mute, Ms. Collingwood. Oh, sorry, you're not talking to us? Okay. All right. Okay, we've done venue. Now, quorum, our terms of reference. Oh, Member O'Neill.
Thanks, Member Carlisle. I just want to make sure you're aware, Member Carlisle, of an email that we received about 10 minutes before the directions hearing commenced, which was correspondence from the school dated the 6th of November.
Yeah, I'm going to come to that.
Terrific. Thank you.
Yeah. Okay. Now we have to sit with a quorum under our terms of reference. That has to be either myself or the Deputy Chair, Member O'Neill, sitting, and there has to be at least 2 of us sitting. So we may not need to sit all 4 of us every day for the hearing. We will probably have the right technical expertise on the panel on the days that the relevant evidence has been presented, but you'll have either myself or Member O'Neill on every day. We understand Total Events will be providing tech support for the hearing as well as today's directions hearing. Just one thing to note, Mr. Townsend, or I think actually Ken might be online here, is we do have a PPV hearing room available for that week of the 13th of January. We just don't have them available for the 2 weeks in December. If we needed it, our preference would be to have a venue in Geelong if we can. But for total events purposes, if you were thinking of running the hearing on Zoom and we use a PPV hearing room, Zoom doesn't work with our tech. So it would have to be run on Teams. I just wanted to bring that.
Yeah, I should have probably mentioned, we didn't see any problem with the Geelong venue in the January dates. It was just in the lead-up, so we would have assumed we're going to Geelong for the January week either way. It's only if we can't get a venue for the pre-Christmas. Yeah.
Okay. All right, now, next thing on the list to discuss is a site inspection. Now, we, like you, Mr. Townsend, think we will need a more targeted site inspection this time round than what we had last time round, given the nature of, or the scope of our remit. We think that we will need to see the refinery site, refinery pier, oh, hang on, I'm reading from the wrong list here. Yep, so the project area, the refinery pier, refinery site, and, you know, we can do our own unaccompanied inspection of the sort of areas around that. We think we need to see Corio Bay and Lime Burners Bay, but we think we can see what we need to see from land. I don't think we'll need a boat like we had last time. And we can again do that on an unaccompanied basis. Ms. Collingwood, we think we will need to come and see the school and understand its relationship, particularly for Member Burgermeister, who wasn't on the committee last time round, and noise being a key issue for the school. We're going to need to come and see the school and understand its relationship to the project area. Our preliminary view is that we won't need the detailed tour of the school's facilities that we had last time. And we may not need access inside any of the school buildings, but we will need to access the school grounds, particularly to identify locations that are the subject of nighttime noise limits.
That can be easily arranged. That's no problem.
Okay, terrific. And we also want to cover on our site inspection receptor locations used for determining the baseline noise and air emission levels. So I think we've got access to the information of where those receptor locations are located in the relevant technical reports. And I think we can access those areas or near enough to those areas from public realm. I don't think any of those will need to be accompanied. I'm getting a big nod from Member Burgermeister, so that's great. Mr. Townsend, do you think there's anything else we need to see?
No, I think as so far as those receptors are concerned, there's one on Avalon College, which I think is on the school site, or effectively we might need to combine that into that day trip. But the others, if they're, what we're taking from your suggestion as we map this out is that where they're readily viewable or from the public realm, you might incorporate them into your unaccompanied inspection, and we're not, you're relying on us otherwise to get you onto private land if there are any.
Yes. What, anything else you think we need to see? And are there any other suggestions? What we'll do after today is we'll circulate some directions and give parties the opportunity to have a think about anything else you think we need to see, and you can nominate any locations that you want us to visit within a few days after today's directions hearing. But is there any other location that anyone wanted to bring to our attention now? If you just use the raise your hand button, if you've got anything to add. All right, now, obviously we're going to need to be accompanied to see the pier and the refinery and the school and possibly the Avalon as well. Mr. Townsend, are there, I'm assuming there might be some limitations around the number of people that can access the refinery, and you're going to have some induction kind of requirements for health and safety reasons?
Yes, look, I know when I did it recently, and you probably did last time, it was done by bus. And that enabled those matters to be handled efficiently, induction and also keeping people in a vehicle and as a location. Can I suggest that I asked the Viva team to mock something up
Yep.
for the committee and get that to you ASAP. We'll share it with Ms. Collingwood and her team to try and lock in how it suits with their site, because they may not want to come to the other, but go to that bit. But can I assume that we'll mock it up on the basis that we start at the office at the refinery, so that if there is any induction and high vis that can be done, we'll arrange a bus. But at some point we might need an indication through you of how many people others expect to be attending.
Yes.
And it's a matter of, yeah, and so it'll be dependent on numbers to some degree on how much whether we have a problem or not.
Okay.
Yeah.
What we'll do, so for those who don't know what an accompanied site inspection is all about, so if we have an accompanied site inspection, parties are invited to attend that if you want to, subject to any limits we may have around numbers and sort of safety issues and those sorts of things. So we will ask the parties to give us an indication within the next few days as to whether they intend to join that accompanied site inspection. Then we can have a slightly more informed conversation with Viva about buses and any limits that we might have to work around.
Are we targeting, Member Carlisle, the week of the 2nd of December? And is there a date the committee would like to tell us to? We can do any of those dates in that week, but
yeah,
if you give us one, we'll aim for it. Yep.
We're proposing Wednesday, the 4th of December. And Ms. Collingwood, likewise, if we needed, do you have concerns around, numbers and stuff? If people wanted to join the inspection of the sites on the school grounds, are there limits we need to be working around there?
I'll have to get instructions about that. I think if it's accompanied, there's more flexibility, obviously, but yes, I can advise the committee within a couple of days or a day.
Yep. Will the school term be finished? Will the borders have gone home by 4th of December?
I don't know. I'll find that out.
Okay, so we just need to work around that as well. Okay, so next is a couple of procedural issues that we need to talk about. The first one is one that we wanted to discuss with Impact Assessment Unit. So this is one for you, Mr. Gutierrez or Ms. Mitchell. So clause 4 of our terms of reference states that, the department has engaged independent peer review to review and provide advice regarding the supplementary EES, including the proponent's proposed study program, specifically in relation to coastal processes, hydrodynamics, marine ecology and birds. We just want to clarify that that's the Stantec review. That's the only peer review we're talking about.
Yes.
Okay, and we understand that Stantec has reviewed both Technical Report A, which is the marine study, and Technical Report B, which is the threatened and migratory bird study.
That's right.
Yep. Okay, and clause 4 of our terms of reference states that DTP will keep Stantec engaged in case the committee has any questions for them. I can foreshadow that we do have questions for Stantec. And we just need to discuss an appropriate process for that. This is maybe something you need to take on notice, but I'll tell you what we're proposing. We would put a written request to Stantec by this Wednesday, seeking, that's tomorrow, yes, seeking Stantec's, so CEE responded to Stantec's peer review, and that's in Technical Appendix A of Technical Report A. So that's the first appendix to the marine study. What we don't have is Stantec's response to the CEE response. So we're proposing to ask Stantec to give us its views on that technical appendix first up. We're proposing that we would aim to get Stantec's advice in response to that question by the 20th of November. So that's another week. So Wednesday next week. And then we would put, if we had any further questions for Stantec based on their response to the CEE material we would put any additional questions to Stantec in writing by Wednesday, the 4th of December, so before the hearing starts, and aim to get a written response from Stantec to any of those further questions by Monday, the 9th of December, which would be day one of the hearing. Now, that's all a bit up in the air because we don't know whether we're going to have any further questions after we review whatever Stantec gives us in response to the initial question, and indeed after we review the marine evidence. But they're the kind of timeframes we're talking about. It would also be really useful to the committee if Stantec could be on standby to respond to any kind of further questions that might come up during the course of the hearing. So unless you're in a position to, you may need to go away and have a think about that. But I'll ask you to, and we'll put that in writing to you just so you've got the various dates that we're proposing. But that would be an open process. So anything that we would ask in writing of Stantec, we would copy all of the parties in on that, and all of the parties would be copied in on anything we get back from Stantec.
Thank you.
I'll come back to you, Mr. Townsend. Is there anything you wanted to say about that, Mr. Gutierrez?
Yeah, thank you, Member Carlisle. I think we would only request that the written request for information or advice be directed to the department instead of directly to Stantec, given they're engaged by the department. And in terms of the dates, yes, I would need to take that on notice and let you know afterwards if that works.
Yeah, okay.
Thank you.
We will write to you after today, just confirming those dates. Mr. Townsend?
Thank you. I just we very much support that approach that there should be a closing off of that peer review. We'd identified it ourselves, but we were going to approach the department on the basis, because it's iterative, that they ought be able to and should meet with or seek any questions of the authors directly. So can I suggest in the committees, with the committee directing that happen, that you leave open that opportunity for Stantec to, of course, directly contact the authors as they have been doing, or with any queries, rather than it becoming a sort of now via the committee approach. If it's appropriate for them to find out what did you mean here, or what did you do there, or where's your table, they should continue just to ask for it and meet with them to do it. But if you could include that in your, if you could not foreclose on that in your letter, it would be entirely consistent with what we were proposing in reaching out the department anyway to seek closure on the, or a final position. And we'll probably also do that. But so if that's okay, that was all I wanted to add to that proposition.
Okay. Ms. Collingwood, is there anything you wanted to add in relation to that Stantec involvement?
No, thank you.
Okay. All right, well, we'll document all of that after today. Next thing on the list is the school's request for information that it put to Viva, I think, last week on the 6th or 7th of November. How are you going with that, Ms. Collingwood?
We've actually provided a copy of that correspondence to you this morning. We did provide that request for information last Wednesday. We've had a number of replies from Davis Advisory indicating that they're getting instructions, the most recent of which was on Friday, and then we have not heard further. It might be that the proponent fully intends to provide that material soon, but we seek directions from the committee to make sure that that happens. And in terms of the substantive basis for that direction, what you'll see when you review the request for material, first of all, the requests come from our witnesses and expert advisors, and the request has been made on the basis that they need that material to undertake their work and to properly interrogate the SEES.
Yes.
As I said earlier, it's really important that our witnesses are able to do as much as possible, as soon as possible, to make sure that they're properly prepared for the hearing. And all of the information that has been requested, and I can take you through it if you'd like me to in some detail, but all of the information that has been requested is material that was made available for the first EES. But further to that, it's material that goes to the heart of the subject matter that's before the committee in terms of each respective discipline. Not only was that material the subject of expert evidence before the committee, but in the deliberations set out in the first report, those deliberations touched on this very material. So we actually think it will be really important for you to have it.
Yeah.
We think that perhaps that's the first and foremost consideration, but it's material that we think that the committee should be interested in and will play a material role in your deliberations again.
Okay.
There's no issue that we're preaching to the converted here, but it just takes time to do it. So we have replied on last Friday that we'll seek instruction. Mr. Wallace has returned today from wherever he's been away. I'm confident, Member Carlisle, that directly between the instructors we can pursue these, but there's no in principle issue with trying to get information and get it as quickly as we can.
Okay. Okay, well, on that basis, it may not be necessary for us to make a direction at this stage. It sounds like the proponent is not opposing the production of that material. It's just a question of timing. I would urge you to see if you can get that material circulated as early as possible for all of the reasons that Ms. Collingwood has outlined. And if we haven't got material that we need or your experts need within the timeframes you need, Ms. Collingwood, I would invite you to seek further directions from the committee at that point. I am hoping that that won't be necessary though.
Thanks, that's sufficient for our purposes.
Okay. Member O'Neill?
Just thinking it might be an appropriate time to ask Mr. Townsend whether he has received instructions regarding a point of clarification of commencement of the directions hearing regarding the availability of the hydrodynamic report and how quickly it can be circulated.
The answer is yes, and it can be provided forthwith. The client will take care of that, but they know which document we're referring to and they're able to provide it.
Thank you.
Okay. That popped into my head and then it popped out of my head, so I'm glad you raised that, Member O'Neill. Next thing on the list is our terms of reference require us to consider the Wadawurrung's views if known. I know what you said earlier, Mr. Townsend, about the conversations that Viva has had with the Wadawurrung and they're not intending to participate in the hearing. And there's the Cultural Heritage Management Plan process that is basically the way that they've chosen to engage. Just because of that terms of reference that requires us to consider their views if known, I think we will reach out to the Wadawurrung and invite them to participate in the hearing, noting that they may choose not to do so. But we just wanted to let the parties know of our intentions in that regard.
Yeah, I think it's important I say this, while I was at liberty to say what I did this morning, I don't purport, nor does Viva, to speak for the Wadawurrung. But I would suggest that it's consistent with if I would suggest to you that if they are to take up the invitation, you might want to be letting them know that it's an in-camera session.
Yes.
Yeah.
Okay. Next thing on the agenda is a request for further information. So we're not proposing to issue a formal request for further information at this stage. We think we are going to get what we need through the Stantec process that we outlined earlier. There is no doubt going to be questions that come up during the hearing that will require a written response, and we'll deal with that during the hearing process. Are there any other procedural matters that you wish to raise at this stage, Mr. Townsend, on behalf of the proponent?
I'll just check before I assume the answer is no. And I'll just check my WhatsApp if that's all right.
Yep.
No, there's nothing else. Thank you very much.
Okay. Ms. Collingwood?
Thank you, and I'm sorry to drag you back to timetabling.
That's all right.
But it has been pressed upon me that if we are going first amongst the submitters, or up front, as it were, then it would be appropriate for us to be scheduled with a short reply, even if it's just 15 minutes or 30 minutes, which we may ultimately give over if there's nothing to say.
Yes.
But just in case there's something arising out of that material that we wish to respond to.
Yep, that can certainly be accommodated. Ms. Chorn?
Thank you, Member Carlisle. My instructors did write to the committee seeking a procedural direction. I understand that
Yep.
You were coming to that.
I am going to come to that.
Okay,
so
well,
there is so
I'll let
much
you follow
stuff
your
to get
process
through.
then.
So much talking from me today, but
No.
I am coming to that. Okay. All right. So next on the agenda, does anyone need a? In fact, I need a quick break. Can we just have a break until 10 to 12? See you in a minute. Okay. Hi again, everyone. Ms. Collingwood, we just checked the Geelong Grammar School terms, and I think the last day of term is Friday, the 5th of December. So you'd still be in term on the proposed site visit.
That's correct.
So, yeah. Just let us know if that's going to present any problems or if we need to work around access to certain parts of the campus. Look, we are nearly there, everyone. The next thing I wanted to do is to just outline some of the directions we're proposing to make, and we're going to come back to that issue, Ms. Chon, about expert conclaves. So the first directions to outline are those in relation to evidence. So we are proposing a staggered provision of evidence with the Viva evidence due on Wednesday, the 20th of November, and everybody else's evidence, which is actually only the school's evidence, due on Thursday, the 28th of November. And I think that's sticking to the dates outlined in our initial letter. Expert witness statements must be confined to the matters that are contained within our terms of reference. Expert statements must comply with the Guide to Expert Evidence, and we'll provide a link to that in the written directions that we circulate after today. We'll ask expert witnesses not to refer to individual submitters by name, and if necessary, they can be referred to by submission number. And we ask that witness statements be provided to us as an unlocked document so that we can copy text out of them for the purposes of our reporting obligations. Now, I think, where did we get to on evidence? So the school's intending to call evidence on marine noise, not intending to call evidence on air. I've got that correct, haven't I, Ms. Collingwood?
Yep, that's correct.
Okay, well, in that case, we think conclaves in those two areas will be of benefit to the committee and to the parties. Now, you've indicated, which is consistent with what we were proposing, that joint expert meetings would be conducted in the week of 2nd December, and that joint expert statements be filed no later than the 5th of December. Mr. Townsend, does that present any problems from your end, or is there anything you wanted to say about that?
No, that's what we anticipated also.
Okay. The school's also seeking a direction that joint expert statements include a table that identifies each issue and the respective opinions of each of the experts in relation to that issue. I think from recollection that may even follow the format of the joint noise expert statements from last time. That would be useful to us, so we support that format for joint expert statements. Now, Ms. Chorn, so EPA has asked that its scientific staff be invited to attend the relevant expert meetings. We're assuming that would be both noise and marine.
So thank you, Member Carlisle. Things have progressed somewhat since we wrote to the committee seeking this procedural direction. If EPA scientific staff were invited to attend the conclaves as observers only, it would be limited to the noise conclave, as that is the area of EPA's predominant focus. My instructions since we sent the correspondence to the committee have changed somewhat. We're not pressing for our participation in the conclaves unless the committee thinks it would be useful. We understand that on the last occasion at the initial EES, EPA scientific staff were invited to attend some of the conclaves, and whilst they didn't sign the expert witness minutes or the expert statement minutes, they did at times actively participate in the conclaves. But we understand that that was because there was, at that stage, the issues were somewhat different, and there were some issues regarding the ambit of the EP Act following recent legislative reforms.
Yes.
Those issues aren't at play here, and the EPA is just reticent to preempt its eventual assessment of the DR applications, which of course can only occur following the Minister's assessment. So at this stage, we're actually not wanting to press that issue further, unless of course the committee thinks it would be useful. But at this stage, we're content to just have those conclaves be between the independent experts that are being called by the respective parties.
Okay. Any views on that from either Mr. Townsend or Ms. Collingwood? No? Okay. Thanks, Ms. Chorn.
Thank you. The only other issue that I did want to raise, it's slightly off topic, but it was contained in that same piece of correspondence, so I'll raise it now. But and particularly so since the issues have developed through the course of this directions hearing, but the EPA would be requesting further a 90-minute time slot rather than the 45 minutes additionally indicated. So that was all I wanted to raise in that respect.
Yep.
Thank you.
That's all good. Thank you very much. Okay. Now, in terms of evidence in chief, so when witnesses present their evidence, and for those who don't participate in these processes all the time, we call that evidence in chief. They're only going to need to summarise key points. So we'll ask witnesses, I know that some of the marine evidence in particular, in fact, both the marine evidence and the noise evidence will be very technical in nature, but if we can at least aim to sort of hit around 30 minutes for evidence in chief, that would be of assistance in keeping to the timetable. If a witness wants to present a summary of their evidence in the form of a PowerPoint presentation or a summary document, that can be presented as part of evidence in chief. But any sort of written material that they want to present on the day will just need to be circulated the day before. Now, cross-examination. So for those who haven't participated in this type of process before, anybody can ask questions of an expert witness. You don't need to be a lawyer to ask questions of the expert witness. So if there are any of our community groups or individual submitters out there who have questions for the experts, you are able to ask those questions. When you are questioning a witness, you have to put questions to the witness. It's not an opportunity to make submissions. You'll have time to do that later in the hearing on the submission days. But if you think an expert has got it wrong, for example, because one of their key assumptions was wrong or something like that, that's something that you should put to the witness in a question. There is a lot more information in that guide I mentioned before about how to put questions to expert witnesses. So if there are any community groups or individuals who are thinking they might want to ask questions of the witnesses, have a look at that guide. Now, in terms of the proponent's submissions, so we'll direct a Part A submission to be circulated on Wednesday, the 20th of November. That's the date that was indicated in our initial letter. And a Part B submission to be presented at the hearing and circulated the day before. So the Part A submission should include just background information that assists the committee and the parties to understand the project. We'd be looking for a broad and high-level description of the project, the design process and the approval process. A broad and high-level summary of the matters addressed in chapters 3 to 9 in the supplementary EES. They're the sort of substantive technical chapters. A submission summary table summarising the issues that have been raised in submissions only insofar as they relate to the relevant environmental matters. We're not asking you to address matters or submissions that are outside our scope, and providing the proponent's initial response. It would be helpful for us if that is based on themes rather than based on individual submitters, particularly given we have 387 individual submissions. And we would like in that Part A submission a detailed response to the submissions from the EPA, which is submission 330, and DECA, which is submission 338. Now, the Part A submission will be taken as read at the hearing, but we may have some questions for you on day one. The Part B submission will then address the issues in detail, so that will include a response to the specific issues raised in submissions and evidence, and any further changes to project documentation in response to submissions and evidence. I'm going to come back to day one project documentation in a minute. We're also expecting a written closing submission. So that will be circulated the day before closing submissions in that week 3 of the hearing. Day 1 documents. So we will direct the proponent to circulate a day 1 version of the environmental mitigation measures and the draft planning scheme amendment. If that can be circulated by Monday, the 2nd of December, that will inform the joint expert meetings. And it can be informed by the written evidence that's already been circulated. We'd ask that the day 1 versions be tracked against the exhibited versions and just show any changes that are proposed in response to the issues raised in submissions or evidence. If we could ask the proponent to make sure that the latest aerial photography of the project area and the surrounds are available at the hearing and able to be screen shared. We're not proposing to have a detailed drafting session scheduled into the timetable. We anticipate that there may be a further version of the environmental mitigation measures and the planning scheme amendment that's produced toward the end of the hearing and circulated with closing submissions. If that is the case, we would provide other parties the opportunity to provide drafting comments in relation to that day 2 version within, say, 5 days of the end of the hearing. Now, there's no specific matters that we wanted the other parties to address in their written submissions, where it's up to you to present your case to us in the way that you see fit. But if you can address the matters that, you know, in a bit more detail that you've put in your original submissions, that would be of great assistance to the committee. I think that was it in terms of directions that we were proposing to make. Mr. Townsend, is there any other procedural matter or any concerns you've got with the directions that we've outlined that you wanted to raise?
No, thank you, Member Carlisle.
Ms. Collingwood?
No, thank you.
Ms. Chorn?
No, thank you.
And are there any questions or anything that anybody else wants to raise before we close the directions hearing today? If you could just use that raise your hand button. Okay. Mr. Allen.
Thank you, Member Carlisle. I represent a body on the far end of the Bellarine Peninsula where the ships will come through the RIP. Our submission is not based on any of the local concerns, but we have a short presentation we would like to place. I asked for 30 minutes speaking time. That is greatly excessive for the amount of time I would like to appear, but I would like to appear still, and it would be even more practicable if it was a hearing in Geelong, because
Yes.
there are no trains between Queenscliff and Geelong since the 1970s. I would like to attend, and with perhaps a 5 to 7 minute window of time assessed. So that's all I need to say. Thank you.
Okay. We'll allocate you 10 minutes because we really deal in 5 or 10 minute blocks. Okay. Thanks, Mr. Allen.
Thank you.
Mr. Townsend?
Thank you. I'm not suggesting you shouldn't hear from Mr. Allen, but we had assumed, and I would take it, that the matters of navigation, safety and the like were among the matters you said are outside the relevant environment matters. So we won't be addressing you on those, but I'm not suggesting you shouldn't. You'll determine who you want to hear from, but just so we're absolutely clear, we won't be addressing you on that. Yeah, thanks.
Mr. Allen, that is worth just reiterating that we're happy to hear from you, particularly since it's only 10 minutes, but if you're raising issues that are outside those 4 relevant environmental matters, we won't be able to make any recommendations about those issues.
I understand that, and I will be very brief. And the matters we raise are largely broad brush rather than individual responses to the proponents' project. So I'll be brief.
Okay. Thanks, Mr. Allen. Any other questions before we close for today? Nope. Okay, well, we will circulate some written directions and a timetable, hopefully by the end of the week. We will follow up in relation to those matters that we needed to follow up with. So, you know, we'll get in touch with the Impact Assessment Unit, just outlining the dates for that Stantec process and confirm dates for site inspection. And there'll be some correspondence at an officer level between PPV and Viva in relation to hearing venues. I just wanted to thank everyone for coming along and participating in today's directions hearing, and we'll see you all at the main hearing. Thanks, everyone.